Hello, Brian.
Good day, everyone. I'm Brian Patterson. This is ENS, and today we're going to deal with what protection do employees in Africa have in respect of business transfers. There are myriad of legal considerations that have to be taken into account in respect of transfer of employment, and I'm joined today by a number of my colleagues who are going to cover very briefly 8 jurisdictions of the African continent, which are as varied from South Africa, which has a fairly developed legal system in respect of such matters, to the new legislation in Mozambique. Alex Ferreira will assist us there, to Rwanda, Uganda, Ghana, Namibia, Mauritius, Kenya, and we're going to look at these jurisdictions within the R. Obviously, we can only touch upon them. We want to look at what the common law position is, the statutory interventions that have taken place, the legal consequences associated with a transfer of business, and also possible tripartite agreements. What's the position in respect of medical aid and pension? What happens to criminal and civil liabilities, and are there any specific requirements in respect of insolvency? So we're going to start this morning with South Africa. Ask my colleague and partner, Joe Matibi, to briefly outline the South African position in respect of transfers of business. Joe.
Yeah, maybe to start with the common law, and hello, everyone. From a common law position, prior to the statutory intervention I'll talk about now, one cannot buy and sell employees. So generally, at a common law level, one would not have the employees transferring over to the buyer of the business if we're dealing with a purchase. There has been a statutory intervention, Brian, and perhaps we can unpack that in terms of Section 197 of our LRA.
All right. How does Section 197, Joe, change the common law position?
Yes. So with that section, the basically what happens is that when there is a transfer of a business or part of it as a going concern, the employees automatically transfer over to the purchaser or the acquirer on the whole no less favorable than that which they had. So basically, the new employer is substituted in place of the old vis-a-vis their contracts of employment, and that happens automatically.
That sounds very much like a number of our viewers are probably familiar with TUPE and the Acquired Rights Directive. Is that similar to what happens in the UK and Europe?
It is similar, with one important proviso or distinguishing point, and that is, of course, South African law doesn't have extraterritorial application. It only applies within the borders of South Africa. I'm not an expert on TUPE nor European legislation, but my understanding of it is that there is some pan-European application in some of the legislation, but certainly in South Africa, it's limited to within the borders of our country.
Okay, so now the employers will transfer, presumably if there is a transfer of a business as a going concern. Are those conditions necessarily going to be identical?
And frankly, there've been quite a lot of, it's fact specific, can I say that? We like to call it a snapshot test. So is when you look at the business prior to the transfer or part of the services, sometimes it's even services that are transferred. We've got garden services which have been found to fall within the purview of a transfer of an undertaking or part of an undertaking. So it's really, is it the same activities which are done on prior to the transfer, and if you look at them that on day 2, are they the same services? So it's a snapshot test. If you take a snapshot from day 1 to day 2, it's the same type of activity that continues, and then that's where you would say it's a going concern, and the consequences then kick in.
Now, Joe, what wiggle room is given to the new employer regarding change terms and conditions of employment?
So the law says it must the new employer must comply with the terms and conditions prior to the transfer, but they must be on the whole not less favorable. Now you may say, what does that mean? As all these things in law, it's all fact specific. I suggest you always seek advice, preferably from excellent lawyers like ourselves. But it's all facts specific, but it's on the whole not less favorable. There is that wiggle room. You can transfer pension funds, provident funds. It doesn't have to be the same fund, but you have to follow the Pension Funds Act, which requires certain administrative actions to be taken with the pension funds adjudicator, including whether the transferred new funds are equitable and there's no real loss of earnings and that type of thing.
Now, let us imagine in a situation that I do in fact want to change things, and everyone agrees, unions, the old employer, the new employer. What options are open to a new employer under those circumstances?
Yeah, so again, provision is made for an agreement to be reached, a tripartite agreement between those parties, in terms of which you agree to vary the normal consequences or the automatic consequences that I spoke about. So you could agree then to changes to change, for instance, some of the consequences which I haven't touched on is all rights and obligations that existed between the old employer and the employees are now between the new and old. Continuity of service would normally automatically happen. There'd be anything done by the old employer would now be taken to be done by the new employer. All those automatic consequences, you can vary them by way of an agreement. It must be a written agreement between the employees on the one hand, represented by the union or whatever, and the old employer and the new employer. So you can have a written agreement along those lines.
Joe, I see certainly in South Africa, from my experience, the competition authorities have weighed in on these things and approving transactions, and increasingly, I'm sure my colleagues will have something to say. This is happening within the African continent and jurisdictions that have competition law. How does that complicate or create challenges for employers in South Africa particularly?
Yeah, we've had, especially at the competition on the competition law space, where the authorities would require some form of undertaking agreement that there'll be no laying offs or retrenchments, as we call them, within a certain period of time. Otherwise, they wouldn't allow the merger or anything like that to happen. So that's more on the competition space. We work obviously closely with our colleagues who are experts in competition law when we deal with that. Insofar as employment law, and maybe let me touch on this quickly because I haven't. In this legislation itself, in 197, it encourages the parties, especially when it comes to retrenchments and accrued benefits and untaken leave and the like, to value or to agree on the value of the untaken leave of the employees that are to be transferred. Similarly, to agree on the value of, if they were to be retrenched and severance was to be payable, what the value of that is. Lastly, on and who is to be, or the apportionment of such liability that has accrued in the event that it becomes due and payable. And that is quite helpful, really, because if you do that, there is a provision which says for a period of 12 months after the transfer, there's joint and several liability between the old and new employer in respect of those accrued claims. And the only way in which you can avoid that joint and several liability, if you can show as the old employer that, look, I took steps to value and apportion these things. So it's quite an important thing that I think it's important as an employer that one does take that into account.
Yeah, I'm just going to, if I may, I think that's very important. If I may just come back to the competition law authorities, I see they often in South Africa will say, well, we'll approve the merger, provided you don't retrench for 12 months. And I've even seen situations where it's been up to 5 years, which obviously has economic and other social and industrial relations consequences. Now, I see our Constitutional Court in South Africa recently weighed in on this and adopted a more purposive, if I can call it that, interpretation of whether there was a causal link to the merger or whether it was economic circumstances that caused a retrenchment. Any comments in that regard?
No, I think certainly. I mean, I think ultimately the question is one of what actually is the cause or the reason that leads to the termination. I mean, I think that's where I would end it for now. I haven't read that judgment in any great detail, but I'm interested in your thoughts as well, now that we are discussing it.
Yes. No, I think my sense was that there's an element of practicality is now being brought to bear, that it has to be merger specific if it's not going to if it's going to bar an employer from retrenching, because those are quite onerous provisions. Maybe one final question, Joe, and that is, do I need to be concerned as a new employer? Obviously, I need to be concerned about civil liabilities, but what's the position of criminal liabilities transfer?
No, I think you don't have to be that concerned on that, on the criminal part of it. It's more the civil liability that one must worry about.
Yes.
Sorry, just that's that. But I wanted to touch on something else quickly before other comments come in, and that is in the realm of where there's a winding up or insolvency, that type of scenario, whether the same consequences, automatic consequences that I spoke about would apply. They wouldn't apply insofar as liabilities are concerned. The liabilities are not transferred prior to the winding up. So that's the one thing. Of course, the contracts will be started or would be transferred with continuity of employment, but the liabilities would remain with the distressed entity.
That's the so-called 197 capital A exception in South Africa.
Yes, indeed.
Okay. Well, Joe, thanks for an excellent exposition today on that. I think that gives us a very good basis to just approach our colleagues and say, well, let's have a look comparatively. How do things differ in your jurisdiction? In some instances, I think we'll see they differ a lot. And in other instances, very little. I'm going to take the easy step and go and speak to our cousins in Namibia, who are often very similar to ourselves. Although I think Charles Visser will deal with this. There are some differences here. Over to you, Charles.
Thank you, Brian. Indeed, the concepts that Joe has ventilated are familiar to us. The common law, we share a joint past legal history, so also the common law is similar to that of South Africa. We have a less developed statutory regime to deal with the fate of workers when it comes to business transfer. Effectively, the Namibian law is probably the statutory law is premised on the Labour Act, specifically Section 34 of the Labour Act, that deals with retrenchment of employees in the instance where the employment becomes redundant and the need arises to terminate the employment of employers due to the transfer of the business. In that instance, if the employees become redundant, the employer would need to retrench the employees before the business can be transferred. And with the retrenchment then comes the necessary statutory notices to the Labour Commissioner, the payment of severance, accrued leave, etc., etc. So that, as I said, envisages the termination of employment contracts. On the other hand, our law do recognize that parties can enter into a tripartite agreement in terms of which current employers, future employers, and the employees can enter into an agreement which will regulate the transfer of these employees to a new employer, to a future employer. Also, a piece of legislation which is relevant is our Competition Act, Brian, as you alluded to, also in South Africa. Under Section 47 of our Competition Act, the Commission is obliged, when it's considered mergers and acquisitions, to consider the fate of employees. And like in South African jurisdiction, our Competition Commission very often imposes requirements underpinning the approval of the merger, which include that employees may not be retrenched for a specific period. And like in Namibia, that can be up to 5 years. I've seen instances like that, like in South Africa. And secondly, the merger is approved on condition that the employees are transferred to the acquiring entity on not less favorable terms on which they were currently or previously employed. So that concept of not less than favorable terms are also a concept that is known and appreciated in Namibia. Effectively, employee is transferred in with all its benefits and rights to the new employer. Likewise, it can include medical aid to benefit, pension fund benefits. Also in Namibia, there may well be a bit of a complication in respect of pension fund and medical aid, because it's not a basic condition of employment. It's an extra that is offered by the employer, and an assessment must be made whether those benefits were contractually enshrined and that the employer is entitled to it or not.
Charles, if I may ask, to what extent is the competition authorities imposing non-retrenchment obligations for approval of the transaction? Normally, this occurs under their ability to take in social and employment considerations in approving the transaction, and they say, "Well, we'll approve the transaction subject to." What are you seeing in Namibia in that regard?
Very often, it's a consideration which is continuously and actively considered by the Competition Commission. Actually, they are statutorily obliged to do so. They must consider the impact which a transaction, a transfer of a merger may have in employment, and they must accordingly deal with it. So statutorily, they're compelled to deal with, and they do so almost on a regular basis. You must appreciate that in your jurisdiction, South African jurisdiction, employment is very much at the forefront of realities, economic development, etc. And it's important that or the government policy is aimed at protecting employment and protecting workers, and therefore, as a general condition, you would see these type of conditions imposed in mergers and acquisition.
Now, it seems from what you're saying to me, Charles, I mean, that tripartite agreements are de rigueur. There appears to be no statutory form of assignment, unlike South Africa, but you've crafted a practice that is very much akin to the South African position. Is that a fair characterization?
Correct, and that's why this tripartite agreement is so important within the Namibian reality. It is so important that the old employer and the future employee, right up at the start of their discussions of acquiring or transferring business or assets or shareholding, it's so important that the fate of employees are considered right up front. It's not only just the business issues that are raised and should be considered. Employees and their fate must be considered right up front. It must be resolved either that the current employer will retrench the employees in accordance with our Labour Act, or that they will be taken over as part of the deal. What that would be entail. It's also important that those tripartite discussions, must include the employees. It's ultimately their fate that's being considered, and whatever commercial dealings will be made will have a direct impact on them. We don't have the luxury of a statute that regulates that, so the parties must regulate that through contract. Get the employers in up front, get the union up in front, play open card, explain to them what a commercial realities are, and give them a choice, because ultimately the employee may have to choose whether to take the transfer to a new employer, with all benefits and rights. Alternatively, to elect to be retrenched, not to take the transfer to the new employer, but rather to terminate the employment of the current employee. And that would then
so that's quite interesting, because I think, as you probably know, within the South African jurisprudence, if an employer can find a new position for an employee which is on the whole not less favorable or substantially the same as the words of the legislation, then it can avoid paying severance pay. Is there an election that, even if you are offered a new job, you're entitled to say, no, I want to cash in my 20 years of service and I'll take the new job? Can you have the money or the box? The money and the box, I should
You
say.
probably can, because it's all within the ambit of an agreement. Statute, there's no statutory regulation. And the last thing that you want to sit with is a union or employers saying, listen, we're not happy to be transferred. You know, it may ultimately result in a situation which is not acceptable to employee or some of the employees. So yes, it is very likely that employees can have the money or the box.
But of course, the new employer then doesn't take over the past service, so there's a benefit. So you're paying it out at an earlier, you're not taking over the liability. Yeah.
Due to the lack of statutory framework, you know, the general advice is when we advise on this issue is to say, old employer retrench, take care of the obligations under the Labour Act, accrued leave, severance. New employer take over the employees from a set date and accrue then those new obligations and rights. That it's a neat, in the absence of a statutory framework, it's a neat way to deal with transfers.
So there's a very clear practice. But just briefly, if you can tell us on pensions and medical aid, how are they dealt with?
It's, you know, if they transferred, the employees must not be transferred on terms less than favorable than they had. So medical aid and pensions can be transferred. Again, as I said, an investigation must be made into whether those benefits were actually contractually offered as part of the terms of employment, or whether they are just offered outside the employment of the conditions of employment. If they form part of employment contract, naturally when transferring takes place, those benefits must follow, depending on the rules and governing pension funds and medical aid funds. If they are offered outside a contract, employment contract, then it's not a guarantee that they will follow into the new employment relationship.
Okay, so Charles, we've got a question from a viewer who wants to know what the position is if the old employer is based in South Africa and the new employer is based in Namibia. I'm not entirely certain I understand the question, because the old employer is selling a vessel. But can we transfer employees between South Africa and Namibia?
I don't see why it can't. Well, there's two scenarios. One, the first scenario is where you have a South African company, a South African entity operating in Namibia, which is a foreign entity registered accordingly in Namibia, and is keen on transferring employees to a Namibian entity or Namibian subsidiary. Naturally, that can be done without much problem. As we say, we have undeveloped, a limited development on when it comes to transfer of employees. Effectively, Section 34 of the Labour Act, are they going to become redundant? Are they going to be taken over as part of the transfer of the business? And the principles which we've ventilated a few moments ago will apply. The second scenario is where you actually have a South African company, a Namibian company in the same group, and you want to transfer employees from South Africa to Namibia, second them. That itself is not a problem, although those type of issues are complicated by work permits, the Immigration Control Act. The Namibians, we are fiercely protective of our workforce, of our people, and secondment or transferring of employee would only be possible if the necessary work permit or work visas have been obtained, and that is generally a difficult endeavor to do.
And I think, as Joe indicated, that that obviously is something that would have to be done by agreement, because South African legislation wouldn't permit a automatic transfer, because we don't apply our legislation extraterritorially any more than you do.
Correct.
So I think that's very interesting. I think we may come back to you on some of these points. I've just got to now move on. I'm going to move on to Mozambique next. I'm going to ask my partner, Alex Ferreira, who practices in our South African office, but is Portuguese speaking, does a lot of work in Mozambique. But Alex, I know that there has been new labor legislation in Mozambique. Can you just tell us what the position briefly is in Mozambique, and compare it to the South African Namibian position?
Yes, Brian, you're right. There has been a new Labour Act which has come into force on the 21st of February this year, which does regulate transfers of business. But the issue was dealt with in the previous act. So it's not something new to Mozambique. And the current position, although it's slightly different to the old position, is in many ways, in fact, 95% of it is the same. And even though Mozambique is a civil law jurisdiction, in other words, it's not a common law jurisdiction, so there's no such thing as a common law position for that reason. In practical terms, it's actually very similar to the position in South Africa, and from what I've heard Charles say this morning, also in Namibia. And the position is that even though the Act doesn't use the exact phrase, there's actually an automatic transfer of the employee unless the old employer and the employee agree that the employee should remain with the old employer, or unless the employee terminates the contract of employment for 3 very specific reasons, which are provided for in the Act. But if one of those 4 circumstances doesn't happen, the employee will transfer automatically to the new employer. And what the Act says is that all rights and obligations pertaining to the transferred employee, including length of service, will pass to the new employer. So practically speaking, it's actually not that different to South Africa. Obviously, the opposite.
Well, let's say, Alex, I am setting up a business in Mozambique and I'm taking over an operation where I'm going to be transferring the employees from operation A to my new operation B. In other words, it's a transfer of a business rather than just a share transaction or stock transaction. What would be the particularly Mozambican issues that you would highlight that an employer must look out for in addressing this sort of situation?
Yeah, so the transfers are regulated by Article 3 of the Act, which regulates the principles that apply. And then Article 84 sets out the procedure. So there are certain procedural requirements. So there is a requirement to consult with the relevant trade unions. And funnily enough, that obligation actually applies to both the old employer and the new employer. So if you are receiving employees, you can't simply assume that there's no consultation requirement with your own union. And then there's certain specific things that have to be consulted on. If you don't reach agreement with the affected employees, then there's also an obligation to inform what's effectively the Labour Department, the Mozambican Labour Department, on the consultation. So you have to report to them. So there's no requirement to reach agreement, but there is an obligation to consult with the unions. And then the other thing, which is Mozambican specific, is there's also, it's not a requirement, but there is a possibility that once again, either employer can post a notice at the workplace whereby it gives the employees 60 days to put forward any claims they may have. And if no claims are received within those 60 days, then the employees forfeit the right to submit further claims. So it can be a useful device used to ensure certainty, to make sure that there's no hidden liability in the business that you're acquiring.
And is there any what's the sort of retrenchment pay that has to, or severance pay that has to be paid out? Is it particularly severe or not severe? Is it similar? Is it 1 week for each completing service?
It's sort of dealt with completely separately. So, it's not like in Namibia where it's a possible outcome, because the position is basically that there's an automatic transfer. And as I said, unless the parties agree that the employee will remain, or unless the employee terminates, if there's just cause for doing so. So it's not really covered as part of the transfer legislation, but there is separate legislation that covers dismissals for operational requirements. And it will depend on how much you earn, and then that will determine what you receive as severance.
But Alex, is it correct to say then the new employer would take over the liability under the normal situation for length of service and any future retrenchments, is similar to South Africa?
Yeah, so what the Mozambican Act expressly provides for is that the new employer and the old employer will be jointly and severally liable for all liabilities of the old employer that arose 12 months prior to the transfer. So it's a bit different. South Africa refers to 12 months after transfer. So these are liabilities that arose 12 months prior to transfer, and they will then pass over jointly and severally to the new employer. So, what that means practically is it's quite important, if you are acquiring a business in Mozambique, to have a good due diligence done to make sure that there's no hidden liabilities, because this will also apply even to employees who may no longer be employed at the transfer date. So anyone dismissed within the 12 months prior to transfer,
and
that claim will also pass.
Am I correct in assuming that it would be civil liability rather than criminal liability?
Well, the Act merely refers to obligations of the old employer. So there's no specific distinction made. So, my interpretation is that the language is loose enough that it could potentially also include criminal liability as well as civil.
Okay, so one must be careful. And then maybe finally, Alex, you've heard from a number of the other panelists about the activism of competition authorities, etc. Is there any similar position in Mozambique that
it's not something, Brian, it's not something that I'm aware of. It's not something that practically comes up. Not yet. I mean, things may change in due course, but for the time being, it's not really a consideration in Mozambique.
Excellent. Well, thanks for that very useful summary, Alex. I'm going to move on now, if I may, to Ghana, and I'm going to ask Nana Ahmed to just compare the situation in Ghana from that in South Africa, Namibia, and Mozambique. Nana.
Hi. So in Ghana, unlike the provision that the 2-pay provides, or in South Africa, where there is some sort of automatic transfer, we have statutory interventions that actually kind of encompass, in a way, the common law position. So in Ghana, employees do not necessarily get transferred automatically when there's a business transfer. Their consent must be sought. So I think that's the major distinction between Ghana and what we've heard from the other jurisdictions so far.
And Ghana, if they don't consent, does the old employer then retrench and the new employer hires a new workforce? Is that the position?
So I'll take them. There are things that we must consider. So I'll take them one by one and just explain them succinctly. So when there's a business transfer, their options are as follows. Number one, the employees may be transferred to the new employer on similar terms. The law does not say similar terms, but it says that the employees must not suffer a diminution in the terms and conditions of employment. That's the wording of the law. They must not suffer a diminution. That means they must be about the same, or same terms and conditions. So in respect of terms and conditions is very wide. It's not just remuneration. It's about even role. There's medical aid, which in Ghana is not statutory. It's not statutory, it's contractual. But if you had it in your former employer and you are being transferred, to the extent, once the law says you must not suffer a diminution, that means you must have a similar medical insurance or medical aid of sorts. It need not be the same provider, but it must have the same coverage more or less. Pensions as well. There are pensions trustees. In Ghana, we have mandatory pensions that every employee is required to be a member of. So that is supposed to be the same thing should apply in the new company. Even if you have optional schemes, that should be, the new employer should take that on. So you must not suffer a diminution in your terms and conditions. So long as you don't suffer a diminution, it's okay. And in that case, if you're an employee and you refuse that offer, if you, to the extent that you haven't suffered a diminution, if you refuse the offer, you can be terminated by the employer by giving notice. In Ghana, you can terminate by giving notice without cause or without giving reason. So to the extent that your terms have not been diminished and you do not take that offer, you can be terminated. So that's number one. Number two, if you are being transferred on lower terms or there's a diminution in your terms, if you accept those terms, it's fine. It's a contractual thing. So if you are being transferred and you are going to have lower terms and you accept it, it's fine. However, if you are being transferred on lower terms and you do not accept those terms, then you are being deemed to be made redundant. Similarly, if there's not going to be a transfer in a business transfer and you are going to be terminated you're not going to be transferred to a new company, you are also deemed to have been made redundant, so you are made redundant. When you are made redundant, what that means is that you are entitled to be paid redundancy pay. Redundancy pay is payable by the transferring employer. Redundancy pay is negotiated if it hasn't been pre-agreed in, say, an employee handbook or something of that sort. If it's been pre-agreed in a handbook, it's applicable. Otherwise, it's something that you must negotiate with the employee. The employer and employer must negotiate. If there's a union, the employer must negotiate with the union. And there's no specific amount. Depending on industries, we see 1 to 3 months for each year served. 1 month, 6 weeks is more common, but some of the industries like oil and gas, petroleum, we do see 3 months for each year served. But 4 weeks is quite usual, I would say, for non-regulated industries like that. So so you must consider, is the person getting a new job with an equal or about equal terms and conditions? There are the repercussions. If it's lower, there are repercussions. If he's being terminated, there are repercussions. And one thing that I would like to note is that when an employer, a new employer, takes an employee on, and there's no law or statutory provision for that, but if a new employer takes on an employee who's been transferred and terminates him or her on notice within, there's no statutory provision, but realistically, say 12 to 18 months immediately, the employee can make a successful claim for unfair termination, because it would be seen as though the former employee simply kind of used that as a strategy to avoid paying redundancy. So
I see.
Yeah, so when you transfer an employee to a new employer, like I said, in Ghana, every employer has a right to terminate on notice, just like an employee has a right to resign on notice. You, however, I mean, I can't say you can't, but if you do, there's a high likelihood or possibility that if the employee who's been terminated a few months or a year after their transfer made a claim at the Labor Commission, the employer will be found liable and will be asked to pay whatever compensation, because he is likely to be found culpable of unfair termination. In Ghana as well, unlike some of the other jurisdictions, we don't have a specific competition act that is applicable to all employees and employers in this kind of situation. So certain industries like the Communications Authority actually have provisions that require you to give a plan as to what happens to your employees in the event of a transfer before they give you approval to, before they give you approval for a transfer, because most of these regulated entities, you need approval to be able to transfer your business.
Well, I wanted to, if I may, Nania, I wanted just to ask you on the competition authorities, do they often impose in Ghana a requirement that you don't retrench for a period of 12 months, or has there been activism on the part of the competition authorities in Ghana? We don't have
a competition. No, we don't have a competition authority. We don't have a general competition authority that is applicable to everybody. So as I'm saying, it is very industry specific. So in the National Communications Authority, for instance, they will ask you for your plan for employees. And as much as possible, they encourage you to keep employees, but they do not force you to do that. So if your employees are going to be terminated, you must comply with law, pay them applicable redundancies and all. But a lot of times, like I said, because it's not in the books, they will kind of, we've seen them kind of negotiate and hold employers hostage. Like, if you don't keep them, we are not going to give you approval, but it's not statutory. But these things do happen, and we've seen it before. Bank of Ghana, so yes, yeah. And in for Bank of Ghana, for instance, as well, when you are transferring a business from one bank, from one entity to another, one financial institution to another, they want to see your plan for employees. They want to see your plan for employees. Yeah, they want to see your plan.
Yeah, no, I'm running out of time, Naniga. So,
okay.
So I think we've got the position. Thank you for such an excellent exposition in Ghana. I'm going to, if I may, move now to Mauritius and to Emmanuel Sozia. Emmanuel, what's the position in Mauritius?
Thanks, Brian. The matter here in Mauritius is actually regulated by statute as well. And I think the general objective of the statute is not different from South Africa in that the default position is that the transferee, the new employer, would take over all employees upon the transfer of business. And the effect on the employment is that the employment would be deemed to be continuous between the two employers. So the years of service would be kept by the employees. Now, if ever there, and this is as well regulated by statute, if there is a termination at the instance of the employer, be it pending transfer or even after transfer, such termination by law will be deemed to be without justification. And unless, of course, whoever is the employer can justify the termination on specific grounds like economic or technological, structural grounds. So that in those cases.
So it's going to be viewed, Emmanuel, as an abuse and accordingly protected. Do you have in Mauritius, is it common to have tripartite agreements? Do the parties get together in the way that we heard in some of the other jurisdictions and reach an agreement on this with trade unions, the old employer, the new employer? Is that fairly common?
Yes, of course. The key in employment law always remains consent of the employee. So the most important things would be to secure their consent to anything which is going to happen to them. But it is very common that such agreements are reached here.
And if the agreements are not reached, Emmanuel, can one compulsorily transfer the employees to the new employer on the same conditions or similar conditions?
Well, the test is similar to what I've heard previously. I think the terms of employment offered by the new employer must be. I just want to be sure about the phrase.
On the whole, not less favorable or similar.
Exactly. The terms must be not less favorable. In those instances, the employee, if the employee does not wish to be transferred, he will not be in a position to claim any unjustified termination of employment and might not be entitled to any compensation if he wishes to stop the agreement.
To what extent in Mauritius, you have competition authorities in Mauritius, to what extent are they weighing in on this, like some of the other jurisdictions, and saying, oh, well, we'll approve the merger, but you must guarantee not to retrench people for 12 months or 2 years or 5 years? To what extent are you seeing competition, regulatory activism?
Yes, we do have a competition commission here in Mauritius, but it seems they would not go as far as what I've heard for South Africa or even Namibia, in that it is doubtful, and we haven't seen it, that they would impose a condition upon merging entities for the employment to be retained. But there is nothing, and this is probably the advice we would give, which prevents the merging entities from offering and undertaking that the employees would be retained by the transferee. And there's nothing which prevents the Competition Commission from taking that into account when giving its decision on a proposed merger.
And if I was opening a business, or had a client that was opening a business in Mauritius, and the employees of the old employer in Mauritius were going to transfer to the new employer, and I wasn't familiar with Mauritius, and I was consulting with you, and I said, well, what do I have to specifically look out for in Mauritius? How is Mauritius? What are the key areas that a prospective investor, new employer must be careful of on transfers of business in Mauritius? Is there anything specific?
Well, probably bear in mind if there's a transfer of business, probably have a look at whether you will have any situation where you have more than one person at any given post, and that might become important when you go up in terms of seniority and in terms of hierarchy, if you want, because severance allowance can be quite important in Mauritius. We talk about 3 months of remuneration by years of service, for any years of service that you have. So if someone is going to be transferred and they have a lot of years of service, you do not want to be in a position, if you are the transferee, where you may have to bear that kind of financial liability.
Yeah, well, that's sage advice. It seems to be a significant liability. Thanks, Emmanuel, for such a succinct exposition on Mauritius. I'm going to move, if I may, now to Uganda, and I'm going to ask Tracy Kagongi to briefly tell us how good day, Tracy. How does Uganda differ from some of the other jurisdictions that we've discussed this morning?
Thank you, Brian. So the position in Uganda is quite similar to that in South Africa. We have a statutory provision under our Employment Act that provides for the treatment of employees in the case of a transfer of business in whole or in part. And it basically states that the employees will automatically be transferred to the new employer along with their contracts, and the terms and conditions thereunder will be transferred to the new employer. The rights and obligations, leave entitlements, salary, and any other benefits contained in the employment contracts would automatically be transferred to the new employer. And the transfer would not affect continuity or service of the employees. They'd retain their length of service.
Can I, Tracy, I mean, is it typical to enter into tripartite agreements that might vary or change that as an alternative to the statutory form of assignment?
Yeah, certain parties will enter into tripartite agreements, but you cannot contract outside the statutory provision. It will merely be to agree on the finer details of the transfer, and maybe apportion liabilities, include relevant warranties and representations to protect the new employer from previous employment claims.
So I'm basically giving effect to the statute rather than it's the finer details. Well, what happens if the union and the old and new employers say, well, we'll agree to retrench and everyone will be paid a severance package and you can hire a new workforce? Is that going to be unlawful, or can that be provided for?
So that would you'd either do that prior to the transfer or after the transfer. But it would have to be on the same terms as if it was an ordinary retrenchment.
Okay. Now, to what extent to what extent in Uganda has the competition authorities weighed in? You've heard some of the stories of competition regulatory activism in other jurisdictions. Are you seeing any sign of that in Uganda?
So in Uganda, we have a new Competition Act that was just recently passed mid last month. The competition committee that was set up under the act has not yet really been set up. The law hasn't yet been implemented. It hasn't been tested. So we are yet to see what level of activism the competition authorities will be imposing on transfer of employees in case of a merger and the like.
And I'm going to ask you the same question I asked Emmanuel. If I was setting up a business in Uganda, let's say as someone who's not from Uganda, and I was going to take over a workforce and they were going to transfer in terms of Ugandan legislation, and you were advising the new employer, what would you say they must watch out for? What are the really important areas that they must keep an eye on?
Yeah, it would be very helpful for the new employer to conduct a due diligence, ascertain what kind of employment liabilities the old employer has, and make sure they know how to deal with those going forward, and maybe impose indemnities within the relevant agreements that they're entering into. Another important thing to take into account is they'd be required to make a notification. The old employer would be required to make a notification to the Commissioner for Labour under the Ministry of Labour of the proposed transfer 30 days prior to the transfer being effected. But we have not seen the Commissioner for Labour intervening in these transfers. It's merely a notification. They'd only come in where there are certain sensitive issues.
Okay, well, thank you very much, Tracy. I'm now going to move to sunny Nairobi, and I'm going to ask Jimmy Samia to just very briefly, Jimmy, if you can tell us what are the specific issues in Kenya that are different that a new employer would need to be careful of in complying with Kenyan legislation?
So Brian, thank you for that. From a Kenya perspective, the position is generally similar. We don't have a specific piece of legislation that governs transfer of employees, and therefore the transfer may be done by one of two ways, either through the mentioned tripartite agreement, or one employer declaring, the old employer declaring employees redundant and the new employer taking them on. We do have a competition authority that, experience has, in past cases, given the new employer conditions of retaining employees. And in those cases, the authority did not give a specific timeline within which the new employees can be terminated. So it was an open order. One thing to note is that Kenya's courts are employee friendly. So upon the new employer taking on the new employees, they will need, for example, if they plan to make any terminations, we don't have termination by will in Kenya. Even though we have notice provisions, there are very prescribed mechanisms of getting rid of employees. So they will probably be taking on the employees from a longer term perspective, unless it's a fixed contract arrangement. The second thing is to note about key employees. Think about who are the key employees who are moving over from the old employer to the new employer. For example, if you have senior management employees who are nearing, let's say a retirement age, then just be aware that upon that happening, there'll be, a key issue in terms of who would be stepping the gap. So you might need to think about, if I'm taking over all the employees from the old employer, and there's some key positions that I need to fill up, then how do you reconcile the two positions? Otherwise, the positions generally the same across the other jurisdictions.
Okay, Jimmy, how typical is the tripartite agreements? I know you have a fairly significant union movement in Kenya. Do they participate? Do parties enter into tripartite agreements to regulate and amend the normal course of events?
So, Brian, that's an interesting question, because we from a Kenyan perspective, trade unions do have an active role in retrenchments. So if there was to be a retrenchment before the transfer of employees, they do have an active role in that. As regards the tripartite agreement, although there's no prescribed or statutory mandate of unions in that process, we have seen cases whereby the union has stepped in for employees and tried to negotiate the terms of a tripartite agreement. So what they'll do is that they'll negotiate a template, which they'll then request the new employer and the old employer to apply across the rest of the employees. So they don't have a statutory role in a tripartite, but they do take an active role of trying to regulations of employees. And it's very common for unions to move to court, for example, try to prevent a business transfer until the employment is sorted out. So that's something to look out for.
Okay. That's interesting. And I also am aware that Kenya's been talking of two-pay type legislation for many years. Is there any sign of that coming to the fore, or is it still on the back burner?
It's something which we've been dreaming about for a long time. I think as employment practitioners, we are really looking forward to the law, but at the current moment, it's not something which is at the forefront of discussions in terms of legislative changes. Most of the changes currently are really around tax in employment laws and social security. Yeah.
And what's the retrenchment liability in Kenya? Is it something? Is it very high, or is it something an new employer must be careful about?
The base minimum is 15 days for every year worked. So typically it depends on how long the employee has worked for the company. The rest are just contractual entitlements that the employee would typically be entitled to. But from a statutory perspective, it's the 15 days of pay for every year worked. Yeah.
Jimmy, thanks for such a clear and succinct exposition. Very valuable. Thank you so much. And if I may now move to Eustacia Nagoga, who from Rwanda, last but not least. Eustacia, if you'd just like to briefly compare Rwanda with the other jurisdictions we've discussed this morning.
Thank you, Brian. I think the position in Rwanda is that there is a statutory intervention. The transfer of business from employment perspective is regulated, although the statute provides just some basic requirements that it imposes that when there is a transfer of business or when there is a new employer, the new employer must observe the terms of the previous contract. That means the validity of the contract with the previous employer must be respected by the new employer. But in terms of what has been said for other jurisdictions, like in South Africa or in Namibia, under Rwandan law, we do not have competition law. We do not have any statutory restrictions as to whether, in case of a transfer of business, in case of a merger approval, the competition authority would impose some restrictions as to whether there will be some time limitation within which employees or the new employer must should respect before they can retrench the employees. So we don't have such a requirement in Rwanda, although it is subject to the conditions. I mean, that could be imposed by the competition authority. In fact, Rwandan competition authority is a new institution. In our practice, we have not had any or we have not seen any merger approval being subject to requirement to observe the employment.
Do you have any sort of feel whether that's likely to come in the future? Because you've heard a number of jurisdictions, competition authorities have said that's part of their bailiwick, and they have sort of through the back door said, well, we will approve the merger if you agree to a non-retrenchment provision for 12 or 24 months or even 5 years. And what would be your prediction in Rwanda? Is that likely to occur, or do you think that they will avoid doing that?
Yeah, I think all will depend on, in Rwanda, the trade unions are not very strong, and that will be advocated by trade unions. But I think something that we don't see in the near future being brought to the competition authority. Yeah.
Stacia, if I could just say, I mean, you've heard all of these jurisdictions. Is there anything specific about Rwanda that you would say to an investing employer who was taking over the transfer of a business between the old Ugandan company and the new and transferring the employees? Beware of this or look out for that. Is there anything you would like to alert our viewers to in Uganda that is really important on transfers of business in your jurisdiction that's different to what you've heard before?
Well, not different from what other speakers have said, but what can just indicate here is for prospective investors out as by experience, we see some new businesses being taken over by new employers, by new businesses or new undertakings. And we find when you're conducting due diligence, there are some liabilities relating to the pension, for instance, in that case, or tax liabilities. So in terms of employment, I would advise them to really check on the liability in terms of pension and ensure that they are taking on board employees who are not subject to any liability from the pension.
So it's do your homework and do your due diligence well, so that you know what liabilities you are taking over. Does that sum it up?
Yes.
Yeah. All right. Well, thank you very much. And thank you to the panelists. I'm going to circle back. We do have some Q&A questions. One of our viewers wants us to deal with Zimbabwe and Botswana. We don't have a panelist in Botswana, although we are very familiar with Botswana and Zimbabwe. So, and we don't have time to deal with that today. Hopefully, maybe in later expositions, we will be able to ensure that we do cover some of the other jurisdictions, but we're focusing basically on our knitting where we have licensed lawyers who understand and are able to respond definitively to these issues. Then, if I may come back to Joe. Joe, you seem popular. There's two questions, which I think you can address. The first is the old question of second generation transfers, and can you explain what a second generation transfer is in terms of 197, And how do you determine if something falls within its ambit? And if I could just ask, does it matter? But
yeah, I was gonna lead with that it really does not matter. It's really the facts. The facts will tell you whether 197 applies. Second generation really would have, especially in an outsourcing arrangement, you outsource, say, cleaning or gardening services for a period of time, and come the end of that period, they either come back to say to the parent company, alternatively outsourced further. That's what was second generation. That's what we're talking about. But in terms of whether the statutory intervention of 197 that I spoke about applies, what really we look at is what really happens at the time of transfer. What is being transferred? Is it a business or part of a business as a going concern? That's the only inquiry that matters, not whether it's first, second, or third generation, but really what is taking place. As I previously said, it's facts specific.
Yeah. Okay, and then we have a question on fairness. I'm not sure this is an easy one to answer, but what is fair and what is not fair. I had a labor consultant the other day told me that life was an unfair labor practice. So the question is, if there's a transfer of services in South Africa and an employee is, the new employer is liable for retrenchment, surely that would have been factored into the purchase price for the sale of the business. And is it unfair to for the new employer then to have to take on the liability? I mean, I think the importance of this question, I mean, we're lawyers, so it's hard to deal with fairness, but really the importance, it seems to me, Joe, is you know, you've got to know, you pointed out, do your due diligence, know your liabilities, and yes, that is something that you'll take into account in the purchase price. I don't.
That's the bottom line. It's business. Business can be cutthroat. You got to know what you're buying or selling, for that matter, and take all those factors into account when negotiating a price. So ultimately, I think it's a hard-nosed business decision that wins the day here, subject to the law, obviously. I've mentioned previously the importance of doing the valuation, knowing what the liability is that you're taking on. But I read the question, 12 months, just joint and several liability period. Well, why must I, as the new employer, be saddled with old liability? And I didn't take that into account. When, you know, that's something that you must be, keep your eyes wide open, as they say.
Well, I think that highlights probably the most important issue that we've covered today with everyone on the panel. All of these jurisdictions, there are similar considerations. The law of one jurisdiction has influenced the other. There is legislative enactments. There are practices that have come into being, but each jurisdiction has its own nuances, and you can very quickly get burnt if you don't do a careful due diligence, take careful legal advice in that jurisdiction and understand what the liabilities are, because that ultimately is going to be factored into the purchase price. So in essence, I would say to everyone, do your homework, seek proper counsel, skilled counsel in those jurisdictions, and just like if one was buying a house or a motor vehicle, know what you're buying, and know what you're taking on. So with that, I'd like to thank all the panelists for their insightful and erudite contributions. And I'm going to leave it there for today. I will promise all the viewers that if there are any questions, if you forward them to me, I will ensure that they get to the panelists and you'll get a response to those questions. So we won't leave it there. Thank you very much for joining today, and we will be having other panels in due course on other interesting topics within the African continent. Thank you very much. Bye-bye.